Well, the much talked about issue of hate speech in India. The Haridwar Dharm Sansad, or the statement of Azam Khan calling Bulandshahr rape case quote-unquote a conspiracy. Are they instances of hate speech? If a sitting minister makes a statement pertaining to a case which is already under investigation, does that statement apparently vitiate a fair investigation? That's a pertinent question to be asked. Should that statement be probed? Should the minister be held accountable? Should law step in and curb such statements? Can the government be held liable if their minister makes a statement which is apparently inflammatory? Should there be special restrictions for Netas, MPs, MLAs when it comes to their statements in the public domain? Well, the Supreme Court of India thinks otherwise. An MP, MLA or a minister has the same right to freedom of expression as any other citizen in this country, and no other special restrictions can be carved out. Hello and welcome to this edition of Let's Talk Law. I am Anusha Soni. Today we talk about hate speech, inflammatory speech and other forms of restricted speech. And what does the Supreme Court judgment say on this matter? Handing down a landmark judgment, the Apex Court Constitution Bench held that a government cannot be made vicariously responsible for remarks made by the minister, even if it concerns the state of affairs. The way this litigation started in the court is also very interesting. Here's an anecdote. In an emotional appeal for justice before the court, the traumatized victims, a woman and her 14-year-old daughter, recounted the horror story of how they were gang raped in front of the girl's father on the deserted National Highway 91 between Noida and Shahjahanpur in UP. In the dead of the night, back in 29th of July 2016. This was the incident that was called quote-unquote a conspiracy. Azam Khan, the SP Mantri at the time of this incident, called it a conspiracy. And Azam Khan is not alone. We have had such instances back in time. TMC leader Kakoli Ghosh Dastidar back in 2012 termed the infamous Park Street case as not one of sexual assault but a misunderstanding during a deal between a woman and quote-unquote her client. The list is endless. But misogyny is not a hate speech in India. It's not a crime. Hate speech. What is hate speech? It can be a tricky subject in a country like India. Sometimes criticism of the government or religious dogmas can be termed as hate speech. Explicit sexual expressions can be curbed to guard quote-unquote public morality. But in a country deeply religious and strongly cultural like India, what is hate speech and what's pushing the limits of freedom of expression can always be contentious. The key takeaway from the Supreme Court judgment is that Netas are not specially liable by virtue of their constitutional position. So for the statement of Azam Khan, the then government of Uttar Pradesh is not vicariously responsible. Should we view this judgment as a free pass for the Netas to say anything or everything? Not really. When it comes to hate speech or contentious statements, the court has put the onus on the government of the day. The powerful dissent of Justice BV Nagarathna points out that it's in fact incumbent upon the legislature to bring in a strong law over this issue. It is incumbent on the political parties to have internal mechanisms to deal with such cases. As for the Supreme Court, it cannot legislate on behalf of the government. Wouldn't that be crossing a line? What is hate speech? Incitement to violence is hate speech. In some parts of the world, insulting individuals based on their sexual orientation is hate speech. Feminists argue that misogyny or anti-women statements should be termed as hate speech. Basically, any group of people may dislike a certain form of thought and expression and may term it as a hate speech. Some people may call criticism of a particular religion as something that should be forbidden. Some may term criticism of the government as an offense of sedition. The lines are blurred and constantly evolving. There is no definite answer. But even in a short case of, say, writing, where a particular leader makes a statement and eventually violence breaks out, even in such a scenario, to prove the causal relationship, which means that the speech caused the riots, it becomes very difficult from an evidentiary point of view. The 1984 anti-Sikh riots or the 1992 riots post the demolition of Babri Masjid are all case in point, with no high-profile convictions. Hate speech is essentially riders on free speech, some form of expression which the state believes is a reasonable restriction. Now, what's reasonable and what's not differs from individual to individual, from one country to another. Pornography is protected under free speech in United States, but hate speech is not just religious incitement. Many kinds of speech are covered under this, including obscenity, violation of morality. Various sections of the Indian Penal Code, including Section 117, 153A, 153B, or 171C, deal with various kinds of offences covered under prohibited speech. Conviction is rare and low in such offences. So while misogyny is not an offence in India, the Constitution has taken a very strong position when it comes to protection of scheduled caste and scheduled tribes. Making caste a slur is an offence. Addressing someone from the SC/ST community by derogatory terms is not just immoral, also illegal in India. That's a legislative and a policy position that has been taken by the government of the day. Let's now come back to the Supreme Court judgment. The court has not given a free pass to anyone by holding that netas and mantris are not specially accountable. In fact, the court has expressed serious concerns over statements by people in power. Justice Nagarathna, in her powerful dissent, says that having regard to their reach appeal, netas should be more responsible and restrained in their speech. But I do wish to highlight a very crucial aspect. The court cannot be called to answer every question. The Lakshman Rekha drawn by the Constitution is one that must be respected. Framing laws and policy is the job of the elected government. So if the government, in its wisdom, feels that there is a need to tighten laws, then it must frame a law to that effect. The court cannot frame new laws or add sections to the Constitution. That would tantamount to judicial overreach, wouldn't it? As far as the issue of hate speech or contentious statements by politicians is concerned, it's also a social question, one pertaining to tolerance. To what extent the electorate is willing to accept people who make such statements. Well, to say that hate speech appeals to the public is also a severe underestimation of the wisdom of the public, the electorate. The debate is far from over. In a constantly evolving society and polity, what is restricted speech and what's not will continue to be pushed over time. The last has not been said, but I would end with the words of Justice Nagarathna, the dissenting judge, and I quote, "Any kind of speech which undermines the values for which our Constitution stands would cause dent on our social and political values." The last on the hate speech is yet to be said. With that, it's a wrap. Thanks for watching.